Disclosures kill patents. Keep everything as secret as you can until you produce the product and put it on the market. If you have to have a non-disclosure agreement, if you've solved a problem, then you need to think about patents or protecting that idea, because that's what might be patentable. First to file, that's who wins. And at the end of the day, that's what patents are. They're solutions to problems. And if you hold on to it and treat it right, it can reward the company, which could eventually reward you. Look around your house. Half that stuff is not covered by a patent, so you might as well go out and try to make money off of it. Getting a patent of what they need to do to make money off this idea is not easy, but it's probably the easiest thing they can do, because getting something to market and getting it out in front of the public eye, that's the hardest part. It's on you to enforce your patent. It's not the government that's going to do it for you.
You've never lost an appeal to the patent board? That's like saying you're undefeated in court. What's the secret?
Well,
So Austin, thank you for coming on our show. And I'd love to begin with talking about patents. Why do people need a patent, high level?
The highest level is it's especially for a lot of people, it's to protect your R&D budget. And without some reward on spending all that money on your research and development and a means to monetize or get a return on investment, they wouldn't do it. So in a way, it's even in English common law, they knew it was a way to push innovation forward and this society forward into a much more technologically advanced society.
You touched on something really interesting there in the global kind of world that we're living in. And, there's a certain geopolitical tectonic shifts happening now, but you said English common law and patents. Do you think that there's an advantage that comes from having the patent law that maybe other cultures or regions don't have?
Oh, I totally believe it. I mean, you've even seen countries that have fundamental issues with it. Like you take China, for example, it doesn't have the strongest IP protection in the world, and they were fundamentally against it. I mean, it's a government monopoly issued to a person, not the government, a person. And even they have come around to see that they need patents to move their society forward. And I think they've proven that it's actually moved their economy forward. I've actually done a lot of work in China. I used to work for a company called Foxconn. And so I would go over there and work with the inventors that were over there. And it took a while to this was years and years ago, but to convince them that, hey, this is valuable. And if you hold on to it and treat it right, you can get a patent and it can reward the company, which could eventually reward you, type thing.
I have a follow-up question to that really quick, since you brought up Foxconn. As I understand it, that was one of the suppliers for iPhones. There's some headlines there that maybe we don't have to get into, but regarding what we're dealing with now with tariffs and reshoring and diversifying our supplier base politically, geographically, et cetera. From what I saw, it was pretty advanced what Foxconn and some of the other suppliers for Apple were doing. Do you think that is replicatable or replicable, whatever the word is, repeatable, let's say, to use smaller words for me? Or do you think that, do you think that's possible that we can diversify our suppliers?
I mean, I think we can. I mean, it's been you've seen a steady movement to all these other countries. Vietnam being a big one, India. I mean, for me personally, I've always thought that India would be the place, but China always kind of had that advantage of, you made the deal with the government, no one could fight you on it. Didn't matter if the providence didn't like it or this or that. What they said went, and businesses like that kind of type of decision making, I guess you would say. But Vietnam, I don't know if they're that heavy handed, and it's my understanding India is not nearly as heavy handed as if the locals have an issue with something happening, you will get the pushback. Probably not as big as in the United States, but similar.
So I understand that you're listed on nearly 700 patents. By the way, is it patent or patent? And does it just depend where you are in the world?
It probably depends on where you are in the world.
You tell us, Becky.
I've heard it said both ways in all accents, so I thought I would check with the guy that would know. How do you say it, Austin?
I just say patents.
Patent. All right, I'm going with that. So you've been listed on nearly 700 patents. Are there any that stick out that made you go, wow, yeah, this is a real game changer. This is a real innovation?
Yeah. So when I worked for Foxconn, the area I focused on was their nanotube technology. And this is the issue with some of, with patents. They may develop a product or a technology that's probably not going to be useful for another 20 years. Right. I mean, this is how development goes with our highly technical society. You know, we were, doing things with carbon nanotube technology that I just was blown away. But the idea of making it marketable at that time was a very far stretch because the base material itself, there was no means to mass produce it or to do these things with it. But we were still, with the research and development, pursuing moving that forward and getting patents. And it may be one of those things where, patents are only good 20 years from the date of filing. That patent might not ever be worth anything because the commercialization of those items might take too long.
So, in your experience, what would you say for founders that are developing something or they have an idea? What are the biggest, maybe top 2 or 3 mistakes that they might make when it comes to their patents, or things they need to know that they often don't?
Disclosures kill patents. Don't tell anybody about your new ideas. Don't go out there and sell it. If you have to, have a non-disclosure agreement. Also, non-disclosure agreements, it's a binding contract and it has the rules of contracts. And if you're just signing an NDA and you're not giving the person that you're disclosing it to something of value, then it's just a promise and it's not a binding NDA. So, everyone's like, "Oh, I have an NDA." I'm like, "Did you adhere to the particulars of that NDA? Did you read it?" Because as the disclosing party, there are, requirements and responsibilities that you need to adhere to, and they don't. And then I'm like, "Well, you may have technically disclosed this." And the other thing yeah, pretty much disclosure. And the other issue is, kind of like, when should you contact a patent attorney or someone? Without proper training, you don't necessarily know what to look for. And I always tell people, if you've solved a problem, then you need to think about patents or protecting that idea, because that's what might be patentable. At the end of the day, that's what patents are. They're solutions to problems. Well established problems that everyone knew about, or new problems that no one even knew about. And that's where you get your patentable subject matter from.
And I would imagine it's easier to patent a product, a physical, tangible thing, than it is to patent maybe a methodology or an idea that solves a problem. Am I right in saying that?
Actually, in my experience, in a weird way, methods are easier to patent than products. So, I've worked with, certain ideas, and we've gone with the method route because we thought getting the actual patent on the product would be difficult in light of the prior art. Because one of the things is, say that you're using something that's old or well known, but you've come up with a new use for it. You can't patent the old product. A toothbrush is a toothbrush, but if you found some crazy way of using a toothbrush that no one ever thought of, then you could patent that method of using the toothbrush. The example I always use is, you remember when aspirin came out and it was the biggest rage for treating heart attacks and heart conditions? You couldn't patent aspirin. It had been around forever.
I think it's called paracetamol in the UK. I don't know if.
No, aspirin's a separate
Okay.
thing.
All right. Good. Great. Sorry.
Sorry.
But you could patent the new use for an old product.
What was the new use for aspirin, out of interest?
Oh, treating heart attacks.
Right. Okay. So it was for something else before it was for treating heart attacks.
Well, it was always a painkiller. I mean, they knew the product. Like, you couldn't patent aspirin. Aspirin had been around forever. But if you discovered that aspirin could treat a heart attack, you could have possibly patented that method of treating a heart attack with a known product. And pharmaceutical companies use this all the time. This is how, like, Botox, has just, blew up. I mean, it was botulism, right? You can't patent botulism, but you can patent the use of using botulism to treat wrinkles. But the original use for it was to treat people who perspired too much, sweaty palms and, underarms and stuff. And then when they realized, hey, we're doing this and it's getting rid of their wrinkles, then they patented a new use for the old product.
It's interesting to hear you talk about like non-disclosure in order to protect the patent or protect your idea. I've faced some people in business that are fairly cagey, and I've also heard like don't assume that you are the first one to think of that idea. Don't assume that Jeff Bezos or whomever hasn't had that idea placed on their desk 6 months ago, and that execution wins over ideation. So I have like some competing kind of like worldviews or orientations, um, and it's interesting to hear you talk about the idea as being sacrosanct. Where do you land, Austin? I mean, I have an assumption, but I'm just curious. Could you like maybe push back a bit on the idea that execution is what matters more than the idea?
Well, I mean, you know, that's why I tell people call me all the time, especially startups and independent business people and this kind of stuff is, you know, getting a patent of what they need to do to make money off this idea is not easy, but it's probably the easiest thing they can do because getting to something to market and getting it out in front of the public eye, that's the hardest part. And so, yes, I mean, I even tell people like, look, we might not be able to get you a patent, but if you believe in your idea, look around your house. Half that stuff is not covered by a patent. So you might as well go out and try to make money off of it. The patent is almost like just a form of, an extra insurance or competitive edge in moving forward, but it's not the end all be all in you trying to build a company.
Mm-hmm. There's so much opportunity out there. It's staggering. We tend to like, well, at least I have assumed that we've like most of the things around us. That's the best it could be, or that's the end state, and that's far from the truth, I believe. I was speaking to some gentlemen on a trip who were celebrating selling their company. I asked them what they did, and essentially they went on Amazon. They saw some mosquito fans, like fans that simultaneously maybe repelled mosquitoes. They looked for the testimonials underneath it to see what the pain points were or how people could improve it. And then they went to suppliers in a few countries and said, can you do this? Until they got the right one. They worked on the pricing and unit economics of it and all that. Eventually got a winning formula and sold it to Amazon for like $8 million. Now, it doesn't make the cover of Fortune magazine or something like that, but that's repeatable. Like you can totally do that with the toothbrush, with like everything. And it's really interesting to see like this different viewpoint. Like you don't have to necessarily, I mean, I like it when people reinvent the wheel, catching rockets out of the sky, but like at the same time, you don't have to if you want to chill in Bali, So it's just interesting to see. There's so many options out there.
Yeah, I mean that's it always goes back to I grew up in the I guess I mean graduated college in '99, so South Park was a thing of mine. The underwear, I don't know if you've ever seen it, the underwear gnome theory, economic theory, and it was always like do something question mark profit. And
Oh yeah,
it's the
yeah,
people
I
who
heard that.
can figure out that question mark is the ones who make the money. And sometimes inventors are not the best business people. Sometimes business people are not inventive. And the ones that I've seen work pretty good is when they have a partnership that someone can push this, but you do need someone who looks at things differently to solve these problems a lot of times.
You've never lost an appeal to the patent board.
Correct.
That's like saying you're undefeated in court. What's the secret to your winning strategy? What's your secret to your your rating there?
Well, I would say I only suggest we go when I know I'm absolutely right. So
Pick your
I pick my
battles.
battles because at the end of the day,
Yeah.
it's a huge investment on the part of the inventor or the client. I'm not going to push them to an appeal unless I'm absolutely positive that I'm right and the examiner is wrong. But I
Mm.
mean, the fact that I couldn't convince the examiner that they were wrong is bothersome. I wish I could have, but I didn't. But sometimes that's why you have to go to the appeal.
Can you tell us about one of the toughest appeals you've fought? What made it hard, and how you convinced the board?
Um, I mean, it's all technical. It's like just so like, you know, are they applying the law in the right way or something like this? There was one appeal that I was dealing with an examiner that was just giving me a huge hard time. And I actually believe there was personal animosity in this, and I ended up winning. But it was just kind of like, once you bring it to someone who, like a judge or something, you're like, here's all the things that have happened during the, you know, 3 years of this case. And then they agreed with me, and that brought a positive conclusion to the patent application.
You mentioned 3 years of a case, and that was, I know, just an example that you gave there. Roughly, how long does it take from the first second that an inventor or founder speaks with you through to they get their patent? How long would that take on average?
Well, I guess we'll break it up. So to write and prepare the application, depending upon, you know, several factors, you're generally looking at like a month or less to get it to the patent office. But once you get it to the patent office, you're looking at 2 to 3 years before they even look at it. And then with this one, it was like 3 extra years of arguing with the examiner. So I mean, it can go, and so it's 20 years from the date of filing as the life of your patent, but you have no patentable rights until it issues.
Right, which could take 3 years or more.
Correct.
Right.
But if they find that the patent office was the cause of a too much delay, they will actually extend the life of your patent past that 20 years.
What is it that makes it take so long for them to look at it in the first place? Is it supply and demand?
Yeah. So I was an examiner there, and they were always pushing us like every patent application before, you know, as of this date, which was like 3 years, it has to be done by this date. So they were trying to push the pendency. It's just hard because, I mean, patent examiners, it's a very, I don't want to say it is a tough job. It's one of these jobs you lock yourself in your room basically, and you just research all day. And, you know, it takes a special person and personality to be able to do that for 20 some odd years. You know, then they become, you know, experts in their field, and the time that they're given per case decreases, but it still takes time to do every single one. That knowledge does not come quickly. So that's basically what it is. Like, you could hire a flood of patent examiners, and it still would take, you know, years and years and years before they got up to speed to where they would be very efficient. And then two, technology changes. You're just like, all of a sudden, like, I remember when I was there, like business methods, which were basically like internet software and this and that, just flooded. And they were begging for examiners to leave their position. Now understand, once you get comfortable with your art, you know it, and you're able to do your job in a much more efficient way. And the way the patent office works is generally a point system. You did this much work per, you know, and if you tend to do it, I mean, technically you're supposed to be there your full 80 hours and this, and I mean, 40 hours and this and that. But, you know, if you could knock it out in 5 hours, you had 3 hours to yourself to do what you wanted. You just had to be in the office, but you had X amount of work to do. So they were begging for people to get to the internet software area. And so people were leaving, but you were leaving the area that you were comfortable with into something that you weren't efficient with. And therefore, your number per cases that you had to do became much harder. But then the Dobbs, I'm sorry, not Dobbs, sorry, that was a big decision. The Alice decision destroyed most patent software in the United States, patentable software.
How so? What happened?
So basically, what it was is like the Supreme Court has always held, or the US has always held, that software is nothing but ones and zeros. It's electrons. So it's an abstract idea. It's not patentable. So what attorneys would do is say, well, it's this, you're basically instructing a machine to do X. So the physicality was the machine, the computer, the hard drive, the, you know, this kind of stuff. And so they were able to patent software just by, you know, arbitrarily attaching it to a computer or some sort of processor. In the Alice decision, Supreme Court said, look, you cannot patent abstract ideas, and you cannot attach it to a generic item as a trick to get around this prohibition. So software patents in the United States are toast. There are some exceptions, and it's very difficult, and, you know, inside, you know, pool or whatever. It's just too difficult to discuss this now. I mean, I'll talk to seasoned attorneys, and we still have disagreements on how the test for patentable software works.
Speaking of that disagreement, I think this could be relevant to business contracting, to interpreting social contracts, like we were talking earlier about, like grassroots versus like top level legislation for adherence to a norm or an ideal. but there seems to be room for interpretation in good faith and even more room for interpretation in bad faith. And when you look at the letter of the law as opposed to the spirit of the law, it looks like alignment is really important. And I can imagine something, I don't know what a patent looks like, but I imagine it's longer than one page and perhaps many words. And so it's like, how do you agree on like the definition of a word, or like when your opposite number says, no, that's the wrong interpretation of this clause or this word. How do you find agreement? How do you use analogy? Do you use precedent? Do you like can you talk us through how you align with someone who is fundamentally opposed to your view of reality?
Well, that one's tough because you're right. It's a word. And typically, like, say we're describing a structure, you know, there are 15 different words that could describe, the same element. So we have a lot of issues there. Um, because one of the biggest things is like the examiners are supposed to look at a claim, look at the claim terms, and use the broadest reasonable interpretation of that claim. But you start getting into a rabbit hole of what a word means, and it can turn into a nightmare. I mean, we all go back to the famous one that depends upon what the definition of is. And if we can't agree to what that is, I mean, it's such a basic word, but there are times with examiners that we'll go down this hole, and I understand what they're saying, but this word has meaning in general lexicon. We all know what it means. But if you really start tearing it apart, you can tear apart every single word. And so if you're litigating a patent, there's typically there's a mini trial before the real trial, and it's called a Markman hearing. And basically what that is a hearing to determine what do the words of the claims actually mean. Then depending upon that decision from the judge, then you go through and see if the infringing product or the alleged infringing product meets the definitions of the terms that the court had set.
There's something I want to push back on that you said earlier. Maybe not push back on, but just maybe shine some light from a different perspective that you might even agree with, but is something that I've noticed. You said that as you get better at your art, it gets more efficient. And I wanted to share that I think everything is a trade-off. I don't think there's it's not like it's only good. I think you can do more like checkboxing faster, but that we live in a fluid and reality, and you have more evidence to suggest that you don't need to change. Whereas someone who is maybe new, wet behind the ears, would be like more aware with the landscape and say, what is this? Like, don't worry about that. That doesn't come to my checkboxing. Or like, you might be less curious because you can get more done. And I'm not saying that it's entirely good or bad, but just that sometimes by going into an area where you are uncomfortable, you can have some really vital contributions, I believe, that are at odds with the people that are experts at their craft. And I'm curious, with you being an expert at your craft, how does that land for you?
Well, we were talking about examiners and the whole thing about the examiners, and I would have to push back because I've seen, so back when I was there, we had these things called shoes, and you had to physically go find copies of patents and then add them to the file in this. So I would go to this guy who'd been there for 25 years, and he literally I was like, I'm looking for this. I can't find it. Like, I know it's got to be out there somewhere. And he would just go to these shoes, and what the shoes were just stacks of drawers full of patents, right? And documentation and this kind of stuff. He'd be like, it's in one of these two. And that's where the experience had come in, because at the end of the day, it's a research job. And if you know your area, specific area, and trust me, they hone it down to you're an examiner in this area, it's very limited to the exact stuff that you're doing. And just their ability to find the art like this, that's where the experience had come in. It wasn't so much that, I hate to say it, there's not a lot of imagination used in patent rejections. If there is, then you're going to get torn apart as an examiner. Either it's in the reference or it's not. So that's kind of the, experience in that field. Now, I understand what you're saying in other fields, but this is a plain knowledge-based, what is there and what is not there.
Fair point. I'll continue respecting my elders. Thank you.
So let's say somebody is a founder, they've got an idea, they've got a pitch deck ready to go. We talked about non-disclosures, but what are other things from a legal perspective that founder needs to make sure that they have checked before they really start?
So you need a patent application because, as you were saying before, David, NDAs, you go to someone like Bezos, he's not going to sign one. You go to these VC, you go to anybody who's in this industry a lot, they're not going to sign one because too many companies have, and big companies aren't either, because they've been sued because someone signed an NDA in LA while someone for that company is working on the same idea in New York. They never knew each other, but that person over there has some lawsuit to bring. So they're like, forget it, we're not going to do this.
I was wondering why that was, like why they wouldn't sign NDAs. I thought it was just because they wanted the optionality to move if they really liked the idea. But you're like, yeah, it'd get messy.
Yes, but I'll tell you another story about a client whose NDA actually saved them. But so if you are going in with a deck and you want to go find investors and it's the type of thing where no one's going to sign an NDA, have your patent applications already filed and that process moving along, because at least you're first to the patent office in that space. Then you come up with a lot of times that people want to discuss their idea, and I call it shaking the tree. Once you go and you tell people about your idea, you're typically telling smart people, or people have a different paradigm, and they might come up with improvements. And then if you try to incorporate that, you're stuck with them as a co-inventor. So in my NDAs, I make sure that it's very clear that, if you're going to a manufacturer or someone that you're paying to help you with it, anything they develop on your project belongs to you. They agree to assign it, because you do have that shake the tree problem, as I call it. And then the story of the person whose NDA actually saved them was a local case. Basically, I don't want to get too far into the details of the technology, but she had this product, and then this large multinational corporation came in and was like, we want to help you with it. 2 weeks before she was going to release her product, or a certain amount of time, they released a copy of her product. Granted, the patent would have hopefully come through, but you're dealing with a multinational corporation. You're going to spend tons of money on that. But if they had signed an NDA, which they did, which bound their, fully owned, corporate or, wholly owned subsidiaries, covered everyone in that corporate structure, she was able to use that as a much more effective means of, you took something from me, much faster than the patent litigation would.
So if you're saying if you can get NDA signed.
Correct. My suggestion always is keep everything as secret as you can until you produce the product and put it on the market. And even then, keep your manufacturers and anyone you're working with NDAs, because if your product is not evolving, then it's going to die.
Yeah, well, I was about to open out this actually a lot that's sparking ideas in me. And it seems, speaking of ideas, it sounds like you're the person to talk to, Austin, when I have my next bright idea. But I just wanted to ask you, do you think the US patent system is helping or hurting innovation right now? And if you could fix one thing, what would it be?
That's tough. I mean, it's the short-term pain for the long-term gain. That's always the issue. And, when we were allowed to have software, Jobs was complaining. I assume Musk was complaining at the time of like, the software patents are killing us. And you're getting these software patents on like.
In fairness, they seem to be doing all right.
Yes. But, it can hurt furthering innovation. I mean, the one I always love is.
Can you explain to us? Sorry I do want to hear the one that you love, but I mean, me, and I'm assuming anyone like me doesn't quite grasp how it's hurting innovation, because we see these people as titans on their own Mount Rushmore of technological progress. How are they hindered by the software lack of software patents or something like that? I'm not saying they weren't, but could you help us understand?
Well, I mean, what brought down BlackBerry?
What was it? The iPhone?
Well, it was, honestly, it was REM or RIM or something like that. And it's been years and years, decades. So please don't quote me on all the specifics. But it was basically a firm in, I believe, Virginia, went out and bought distressed patents, or basically patents from distressed startup companies. And then what they found was they found this one little patent that BlackBerry was basically infringing. Knew they were
Wow.
infringing or something, and I think it was $750 million, and it was just too much for them to bear, and it almost totally wiped out the company. And the issue is, the patent trolls, what they call them.
Hmm.
It's people who have patents and only keep them as landmines for others to step on.
Huh.
And that leads
Go
me
ahead.
to ask, because I was thinking this, that if you're a founder with an idea and you think you're brilliant, and of course nobody's ever thought of this before, how would you know if that idea specifically has already been patented? And I'm sure people must accidentally step on these mines because they don't know that it's already been patented. Is there an easy way for people to check? I assume you have to be very specific with the language that you're searching for to find the patent. How would that play out?
Well, you do patent searches, but understand patents get, like you said, you can go through the entire process, get your patent, and then someone finds something that invalidates it. So, I mean, there's all these things because I always tell my clients, look, we're going to do a prior art search, and it's going to cost $1,000 to $1,500. But if your patent if your product makes it, someone's going to spend tens of thousands, possibly hundreds of thousands of dollars doing a prior art search to try to invalidate your patent that's already issued. Because if they can invalidate it, they can practice the technology. And you did all the hard work of, you know, you did all the hard work of proving that there's a market out there for your idea.
I have a theory that, how OpenAI, like if you use ChatGPT, it's like still stuck in 2024. Like it thinks it's 2024 because it doesn't have like real world data. I have a theory that if you cut a $10 billion check to support OpenAI, you aren't in 2024 using their service. I think basically you have everyone's ideas using the technology as if it were 2024, and then you can apply it to the real time AI GPT-5 or whatever is about to be rolled out to the public. What are your thoughts on that?
Well, I mean, I know that they're having a big issue of like, you've scrubbed all our data, which was our data, and you've incorporated it into your learning language model. What do you do there? I mean, it relies on other people's property to make this stuff. So I don't know how the future of that is going to work.
And when you're talking about these mines, these patent mines, or different ways in which you can get tripped up, it seems to be like a situation where everyone has to play the same game. Because what do you do if there's a different power that doesn't? They're like, nope, I don't believe that. I don't follow those rules. Does it still hold water?
Well, I mean, that's what the courts are for. If they don't believe it, then you sue them, and you go out there and you enforce your patent, and it's on you to enforce your patent. It's not the government that's going to do it for you.
And then you could get like maybe settle outside a court or something like that. It just puts some pressure on the presumably another power, if not a bigger power, um, in the case of BlackBerry or something like that. Do you know much about the Samsung Apple kind of patent wars? What would have been, I guess, late 2010s, or like 2008, 9, 10, somewhere in there, where they were like just throwing a bunch of patents at each other and saying, you copied me, no, you copied me first or something. Um, could you provide some color on that for us? Like, was that legitimate? Was that like an overuse of patent law? What are your opinions there, or observations as a professional, I should say?
So corporations, big companies, mainly use their patent portfolios as shields, whereas smaller companies will use them as a shield and a sword. And what I mean by that is, take Samsung and Apple. One of them got mad and started suing one over one little thing. So what did Samsung or the defendant do? They went through their entire patent portfolio and said, well, I can find at least 10 patents of mine that you're infringing. If you want to do this, let's go to the mat. And that's kind of what happened. I assumed at some point they just settled because it was just too much of the back and forth. So these large corporations amass these large patent portfolios. And a lot of times it's like, don't pick on us, we won't pick on you. we might be infringing here and there, but so are you, I'm sure. But small companies are basically, one product or this. And so they're able just to go out and say, my product is patented by my patent. What are you going to sue me for? And that's kind of how that goes.
So is it kind of like a nuclear arsenal, like mutually assured destruction? Like these corporations just have like a war chest of patents? Like, for example, let's take Apple. Do you have an idea as to how many patents they might have? Like tens of thousands, hundreds of thousands?
I don't know, but I'm sure they have a ton. I mean, every year they produce like who gets the most patents, and forever it was like IBM, and I think they have fallen by the wayside, and it's probably some of the others. But the issue with Apple and Samsung, software patents are dead. So I mean, effectively dead. There are some software that can be patented under certain circumstances, but it's not something they're pushing in much anymore.
Do you get high on your own supply? Do you have any patents yourself?
Yeah, I have a couple myself, just silly little ideas and whatnot. So, it's easy. It's, one of them, a buddy of mine, we filed something and we beat another guy by, I think, 3 months. And so, that's the way. It's first to file. That's who wins. And so if you have an idea, get it to the office. Because I've actually seen it personally. You beat a guy by 3 months, you win.
Mm-hmm. Out of interest, if you have a patent registered in the States, is that because we are in a globalized country, and we talked a little bit about China and Vietnam, is that recognized in, say, the UK or in the EU or Canada and vice versa? Or does it not matter if you've got a company based in Sweden and a patent is registered in the US? Can the Swedish company basically do what they want? How does that work with different regions?
All patents are local. So you have a US patent, it protects you in the United States, its territories, and that's it.
Even if you're a multinational, so go to Amazon, for example, or Apple, multinational company, their patents, I assume, would be mainly registered in the States, although they may well register them in other countries as well. But if they say don't have one registered in, I don't know why I'm picking on Sweden, but let's go with Sweden, then a Swedish company can copy Apple with no recourse.
Correct. So, but that's the issue. Like I tell my clients all the time, it's like, depending on what you got, and say it's a small product or a product that's most likely eventually going to be built in, say, China or Vietnam or something, you really should look at patenting them in those countries because, to quote a movie, he who controls the spice controls the universe. So even if they could make it in Europe and sell it in Europe, you're going to beat them on the price point. So it's kind of like I don't want to say it's a way of, getting a global power of a patent, but it really helps that if you have it in the manufacturing centers for your product, that would make it cost ineffective for others to copy and sell it in their home countries.
Right. So if it is a multinational company, even if it's not a huge one, would you advise them to get patents in each of the jurisdictions that they work within or that they sell the product within?
Yeah. I mean, you also look at it, say you have a surfing idea or, surfing product. Australia, even though it has, I think, as many people as Florida does, might be a place for you. But Bali wouldn't because there's just not enough people there.
So when you're patenting the idea initially, so right at the early stages, would you say that's the time to think about where you might go in the world and do this process everywhere? Or would you do it a step at a time as you grow?
Well, there's a time limit. So you have to make the decision within a year of your first filing in the United States. Now, a lot of people get confused with this. First filing means provisional or non-provisional application. So within that year, you either have to file in the foreign countries directly through the Paris Treaty, or you have to file what's called a PCT application, a Patent Cooperation Treaty. And that gives you an extra 18 months to file in all the foreign countries that you would want. Generally, there's some excluded from the PCT, but none worth worrying about.
Famous last words.
I know. I don't know. Maybe maybe geopolitical stuff has come in. I don't know if Russia's still in it because I know they got hit with a bunch of things.
I already patented this idea for a new country. Do you ever get if I were to put myself in your shoes, I think I'd be like looking at patent A on my desk, looking at patent B, and being like, wait a minute, if I took this from patent A and this from patent B, I can make patent C. Is that legal? And no, that's not.
No, that would be so
Okay.
unethical. I mean, you know, like,
Well, that's why you're there and I'm here, I
right,
suppose.
right.
So why is that though? Because technically it's not the same thing.
It's one. It's if you're too close to something a client of yours has. I mean, they could sue you. You'd probably lose. It just
So basically, water could get sued by hydrogen and oxygen.
yes.
Okay.
Yeah.
Interesting.
Good
That's
analogy.
interesting. I didn't know that. I thought it was a new product. So that does get really complex. I can see where
It
you have to deconstruct your idea and make sure that you own the patent. So go back. So basically, BlackBerry should have done more due diligence on sweeping the terrain to see if there was an existing patent anywhere.
well, they. I think you'd have to. Don't quote me on this, but I think they knew about it, and that's what made it.
Okay.
But they thought it was from a defunct company, and it was just lost to. But
Okay.
this company made a business of buying patent portfolios from distressed internet startup companies, and then they found the payoff in that
Mm-hmm.
patent.
Interesting. Unexploded
Yeah.
ordnance. Um, what's one invention you wish you patented?
I really don't have. I mean, anything that would make money. The pet rock. I don't know. Like, I wish I would have patented all those things.
Pet rock.
I mean, how many times have
like
you been out there and you're like, "That's clever. I can't believe I didn't think of that." And
Mhm.
but I will tell you, no, honestly, I will tell you the product that I wish I would have patented. So how I actually got started in patents was I was a kid. My dad had a ranch house or a ranch style house in Mississippi, and he had a fire, a small fire, was put out, didn't cause a lot of damage. But that summer, I was in the attic helping him put in a smoke detection system, wired, had to be wired. So for my senior thesis in engineering, I developed a wireless smoke detection system. And that was my thesis. And I look back at it now, I beat Kitty, which is the huge, smoke detector system, by several years. And if I would have pushed that, I would have been probably pretty well off at this point.
I'd argue you wouldn't be you though. I think sometimes regret is like the glue to life. You need those moments to focus like the rest of your life. Without it, you'd be, I think, more aimless. But thank you for sharing that. That's pretty cool. You're hacking before hacking was cool.
We actually built a prototype. You remember those wireless doorbells when they first came out?
Yeah.
Mm-hmm.
So we had two smoke detectors, and when it would go off, it would send the wireless signal to make the other one go off. And then the idea was it would relay through your home.
That's pretty smart. It's pretty brilliant. You could have been a billionaire, Austin. Here you are talking to us. No, but that's, I mean, many of us have many of these ideas. I don't, it's weird. There is a certain amount of ego that comes from like, I thought of this, I did this, that's my name or whatever. But at the same time, I also feel like none of this really belongs to us. Like I'm speaking to you with a language I didn't invent. I'm pulling from knowledge of books that I read or something like that, other people I've spoken with. So it's more like a synthesis in my mind that I partially understand temporally or whatever. It's hard to say like I did this, but obviously some of that is necessary in order to drive us as well. And so I have kind of I don't know if mixed feelings is fair to say, but I wonder if there's a balance to be struck between being too litigious and focused on like ones and zeros, let's say, or this and that sequence, and just getting out there and creating for the sake of creating. Do you find yourself kind of, do you have time to kind of reflect on that dynamic, or are you just more letter of the law, like straight ahead, look at these patents kind of perspective?
I really do truly believe that, well, if patents are being issued for non-worthy patents, I think that's an issue. But if it's a worthy progress moving things forward, I do believe it's worth the short-term pain for the long-term gain. I mean, I know a lot of us talk about the pharmaceutical industry and all this other kind of stuff, but everyone says that second pill is like 2 cents, but the first one was like 2 billion. And we don't look at all the false leads and the deadhead trails they went to get that one pill that might work. And you end up, possibly saving thousands and millions of lives on something that if there were no profit motive, people wouldn't have gone through it. And there is the issue of, with pharmaceuticals, they extend the life of their patents through legal means because they find new uses for it, but the original use can't be patented. So this is, that's why they always come up with different product names. But I do believe
Ah,
that
Okay.
like Propecia and Prosco.
I was going to say, where are those names coming from? Zorloft and stuff. Are these real words?
No, I actually worked somewhat with a buddy of mine at one point, and he was in the pharmaceutical industry. And it's got to be a word that cannot be similarly confused with a different medication. So yes, they have to come up with all these crazy words for new
So
medication.
they're watching like Adam West Batman shows with like as you see those words when the strikes come
Yeah.
on the screen. It's like
Like kapow.
yeah,
Aren't those called automatopoeias or something like that?
yeah.
Yeah. So I wonder then maybe a recent example of that is I think Ozempic used to be or has been used for 20 years ish for diabetes, but it's now obviously being used for general weight loss. So was that the same company that just repatented a new use, or was it a different company that went, we can do something with this?
I don't know. I assume that since they have the inside track of what their product is doing, they would have patented first. But yes, I mean, now they're using it to, drug treatment, right? I mean, they're coming up with all these new uses that they didn't know worked. But if it does work, great.
Yeah, and they'll be patenting each of those new uses as standalone things.
Right, right. For me, it's kind of like the Proscar thing. It was our Propecia. Proscar was a prostate drug, and then the way they were giving it to people, all these guys were growing their hair back, and they're like, "Oh, let's cut it. Let's cut the dosage in half, and then sell it for 3 times as much."
Right. Good business model.
I've got some rapid fire questions for you, Austin. What's the most underrated piece of legal advice?
You need a good attorney.
Weirdest patent you've ever worked on?
When I was at the patent office, I worked on a Jägermeister machine.
Your go-to productivity hack?
Put it on your calendar.
Favorite courtroom drama or legal show?
It used to be Law and Order, but now I guess I don't have one.
If a founder is listening right now, what's one thing they can do today to protect the long-term value of what they're creating?
They should set up a process of reviewing any problems that they solve to determine whether it's patentable or not.
And what's next for you? Anything exciting on the horizon with Bonderer Law?
Nothing too much. I mean, I'm a patent. I basically, when people ask, I write term papers for other people. So nothing too exciting.
Well, I'm sure you've got some really interesting ideas and maybe a peek behind the curtain for, like you said, what's coming up in the next 10 or 20 years. So that's pretty cool. Thank you. Thank you for talking to us today and informing us about like what it's like being in your shoes. It was a really interesting conversation. I appreciate it. And where can people go to follow you?
Bondererpatents.com. I'm the only Bonderer, Bonderer, put in patents that practice patents. So good thing for a weird last name.
Great. And if they want to contact you, just email on the site there.
Yes, sir.
Okay, great. Well, thanks, Austin. Keep up the good work.
Thank you, Oskin.
Bye.